Salutations to all our future judges. In this video, we are going to see the Code of Civil Procedure 1908, Part 10, Section 35A, 35B, 36 and 37. If you have not seen the earlier Part 9, I am providing the link in the description. And if you want to see the earlier parts from Part 1 till this part, you can watch them in the playlist. Link of the playlist in the description.
Section 35A. Generally, you might have a thinking as to how I can claim compensation for any false or vexatious claims against me. There should be some compensation if someone is filing a false case against you and you prove that it is a false case. Then you can get compensation from that person. How to get this compensatory costs with respect to a false or vexatious claim or defenses is explained under section 35A. On a normal reading, you may find this section 35A subclause 1 to be quite confusing. So let me put it in a very simple and easy manner. Imagine I am filing a case against you. The case or the claim I make is false. Then you will state to the court that I am making a false claim. And at a later stage, the court says that my claim is false. That is, my claim is declared to be false by the court. In that case, the court will say that your objection was correct. The court will say that I have to give a compensation to you. This is what is explained in 35A subclause 1. Now the question comes is whether this 35A subclause 1 includes an execution proceeding. The answer is yes. And it does not include appeal or revision. This is very important. They may ask this in multiple choice question. They may ask whether compensatory costs in respect of false or vexatious claims or defenses is included in appeal or revision. The answer is no, it is excluded. And whether it includes an execution proceeding, the answer is yes. Let us move to subclause 2 of section 35A. What is the maximum amount of compensation which can be imposed? The answer is 3000 rupees only. That is the answer. Or there is another option they are given, or exceeding the limits of his pecuniary jurisdiction, whichever amount is less. For example, the pecuniary jurisdiction of a court is say 2000. Then in that case, 2000 will be the maximum limit. If the pecuniary jurisdiction of the court is say 5000, then 3000 will be the maximum limit. There is a proviso which is given here. You can see if there is a small causes court of small causes, and in that case the court has a pecuniary limit of less than 250 rupees. The High Court can give authority to that court to give cost under this section, and that amount should not exceed 250 rupees. And in case if it exceeds 250 rupees, it should not exceed plus more than 100 rupees. The High Court can empower the court to award a cost more than 250 rupees, and that exceeding amount shall be within 100 rupees. To put it in a simple manner, the court can go up to 350 rupees. As simple as that. Generally, they should limit themselves within 250 rupees. But in certain cases, they can cross this 250 rupees and reach up to 350 rupees. But though these things are said, the High Court can fix the limit of amount which any court can award as cost. So put it in a simple manner, High Court has got authority to say to a court that you can take only this much or you can award only this much as cost. Now let us move to subclause 3 under 35A. In this particular subclause 3, it clearly states this fact. If there is an order which is made under this section, will that be a reason for creating an exemption from any criminal liability? The answer is no. To simply understand this particular concept, let us imagine a person is filing a false case, which is also a criminal act, for example. And the court says that you have filed a false case, we are taking action against you, you need to pay compensation. in addition to this compensation, can court punish that person for his criminal act? The answer is yes. So, criminal liability will also be there in addition to compensation. The person cannot take a defense that, see, you have already imposed cost on me. In addition to this, you cannot let me have a criminal liability. The answer is no, he cannot do like that. He has to bear the criminal punishment for the criminal act, as well as he has to pay the compensation. Let us move to subclause 4 of section 35A. If a person has been asked to pay a compensation for his false or vexatious claim, and there is a subsequent suit where they claim damages, already he has been asked to pay a compensation that is still pending, for example, and again another suit is filed saying that this person has to give me damage or compensation, then in that case the earlier compensation which has been awarded will also be taken into consideration in the subsequent suit. Let us move to section 35B, costs for causing delay. Imagine a situation where a person in a suit, it could be a plaintiff or it could be defendant. If they are causing delay, the person who is affected due to the delay can demand for costs. And there are situations under which this can be done. 35B, subclause 1. Imagine a situation where a court is fixing a particular date for hearing a suit or for taking any steps which are required to proceed with the suit further. So the first thing is, if a person who was required to take a step fails to do so on that particular date, or he obtains an adjournment, that is, he takes a date for doing that particular step, or for producing the evidence, or on any other ground. In these two situations, the court can record the reason and it can say that a party who is causing this delay has to pay cost to the other party. And that cost will be with respect to reimbursement of the amount he has incurred, the expenses he has incurred. Imagine plaintiff A is there, defendant B is there. The court says to the plaintiff to take a particular step. In that case, he fails to take that step. A, the plaintiff is not taking that step, due to which the defendant comes to the court and he is not in a position to complete the process because of the delay caused by the plaintiff. In that case, court will say the plaintiff to pay cost to the defendant. Now, the question is whether merely giving cost is sufficient. Is there any other condition which needs to be imposed? So, generally, what the courts do is they ask the person to pay the cost, and they also put one more condition stating that the date next following, that is the next date, that is from the date of such order, what they should do. If it is plaintiff, if the suit is by the plaintiff, if he was ordered by the court to pay cost, or the second point is the defense by the defendant, where the defendant was ordered to pay such cost. To put it in a simple manner, if the court says plaintiff has to pay the cost for his mistake, then the court will put a condition that the next day itself he should complete the process. For example, plaintiff A is there. The court says you bring the witness on this day. He is not bringing the witness on a particular day. So the court will say you pay the money to the defendant. Let us take another scenario. Court is saying to the plaintiff that you need to cross-examine the defendant's witness on this particular day. This plaintiff goes and tries to take an adjournment. He is seeking some time to cross-examine. In that case, the court will impose a cost and it will say you pay money to the defendant witness. So in that case, court will say you pay money today. Tomorrow you cross-examine him. So that is the point they are trying to stress upon in this particular section. And there is an explanation to this. Let us see what is the explanation. Imagine there are three defendants. So the court is saying to the defendant, you pay the cost. Then court can add one more condition saying that You can take your defense only after paying the cost. So if you want to prosecute further, then in that case, you need to pay the cost to the plaintiff. Let us move to subsection 2. Now the question comes to our mind. Imagine a scenario where the plaintiff is directed to pay cost to the defendant. Defendant has not paid the cost. Then what court will do? The court will include this cost when a decree is passed. Generally, they'll put cost. In addition to this cost will also be added there at the time of passing a decree in the suit. And the court will also mention what is the amount to be paid. It will be a separate order. That is very, very important. They can ask this in the exam. It should be a separate order and it should indicate what is the cost. And it will also mention the name, address of the person by whom such cost is to be paid. And immediately that will be executable. Let us move to part 2, execution general. Section 36, application to orders. That has been explained in section 36. Let us try to understand this in a very, very simple manner. A person is trying to execute a decree. Then the provisions of this code will also be applicable to execution of orders. Whether it is decree or order, this code will apply. As simple as that. Let us move to section 37. Generally, the term used is court which passed a decree. That is the word which is used. And what this actually means is explained in this particular section. Generally, this deems to include, that is how they have defined it, if there is something repugnant to the subject or context, something which is repugnant, in that case that will be taken into consideration. But otherwise, in general, this includes in case of a decree which is been passed by a appellate jurisdiction. For example, appeal court is passing a decree. In that case, you cannot consider the appellate court as the court which passed the decree. You should consider the court of first instance as the court which passed the decree. Section 37, subclause B. Imagine there is court A, that is first instance court. Now that court is closed. There is no such court. First instance court, court A is closed. Or it doesn't have the jurisdiction to execute it. Then in that case, what generally we will do is, we'll try to file an application for execution in the newly instituted court. So in that case, that court will be considered to be a court having the jurisdiction to try such a suit. To put it in a very simple manner, we all know that sometimes the jurisdiction are split between bifurcation. They call it as bifurcation. So what they do is, for example, there is one court A. They'll split that court A into court A and court B. The same court is split into two courts. So in that case, the older court will lose its power to take certain cases. So the B court will have that power. So simply A court is substituted by B court. In that case, if we are in a position to file execution application in the B court, then that B court is considered to be a court having jurisdiction to try such a suit. Let us move to the explanation. Imagine a scenario where I have instituted a suit in a court called as A court. Case is going on, case is pending, or case is being processed, or decree is being passed by court A. In that case, the higher court, say high court is saying, you don't have this jurisdiction anymore, give it to some other court. Say court B. So merely this transfer will not take away the right of court A to execute a decree, provided court A has right to execute a decree when I file an application. To put it in a very simple manner, there are two courts, court A and court B. Court A, I am going and filing a petition or a suit. Now, the Supreme Court or the High Court says that court A has no jurisdiction to take this suit. But order has been passed in my case. Now, The High Court is saying you hand over all the papers to Court B. So Court B will have the authority. You can file an execution petition in Court B. There is no question. However, you need to understand that Court A will also have the right to execute the decree if at the time of filing an application for the execution, Court A had jurisdiction to try the said suit. When I am filing an execution decree, the court should have the authority to execute that decree. In that case, Court A will also be eligible to execute the decree.
If you like the video, please do press the thumbs up button and leave your comments in the comment section. And do subscribe the channel and also share the channel with your friends. Let us join hands together and contribute for a learned society. Thank you.